Hello and welcome to the Kenneth for Campbell Law Office Legal Podcast, looking at recent cases. And in this edition, we look at what's called an unpublished case by the Appellate Division called State versus Michael O'Neill. And the reason why we discuss this is because it deals with something called the HGN horizontal gaze nystagmus test. And the Appellate Division opinion here said HGN, again, is non-admissible in a DWI case. The defendant here appealed his DWI conviction. The defendant argued that horizontal gaze nystagmus test should not have been considered in the case at chief, and the state failed to prove by competent evidence the 20-minute observation period required by the Alcotest was done. The testing officer admitted he did not time the 20 minutes himself. The only evidence introduced at trial as proof of the 20 minutes was the officer's statement that the dispatcher told him the time was up. Appellate Division said that's not enough. The time relayed by the dispatcher was a statement for the purposes of meeting the state's obligation. It's hearsay. The Confrontation Clause requires that dispatcher would have to be subject to come to court and be subject to cross-examination. Here, the dispatcher did not testify, so the Alcotest could not be used as evidence of the defendant's guilt. The court also noted that it's long been held that the HGN test could be used only to establish probable cause to arrest for DWI, but it lacks sufficient scientific reliability to warrant admission as evidence of guilt. The admission of defendant's HGN was not harmless ever, and therefore the conviction was reversed, and that's State versus Michael O'Neill. For other information on DWI and DWI defense, visit website njlaws.com. And for representation, contact Ken Verkammen's office in Edison at 732-572-0500. Thank you.